President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
I now come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdulrahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyse the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyze it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in the dock at this court, nor in the dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pretrial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects. Judge Höhler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Höhler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I am forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte, then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the President, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated, and finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pretrial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence is the fact that some of the victims are unidentified, making it virtually impossible for the defence to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness: documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the sixth weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the 3 counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward: that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay, and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method, that, Your Honours, is conjecture. And we would submit that Article 61(7) of the Rome Statute does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of Incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If Your Honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in